This honorable court is now in session. Please be seated.
Good afternoon. We're going to have a new panel for this afternoon. On my right, Judge Armstrong from Shelby County. On my left, Judge Usman from Davidson County, and I'm Judge Golden from Shelby County. Any messages or announcements?
No, Your Honor.
You may call the case.
Terry Rainwaters et al. Versus Tennessee Wildlife Resources Agency et al.
Before we start, are we having one attorney for each side?
Yes, Your Honor.
Yes, Your Honor. All right, you may proceed.
Good afternoon. May it please the court, Amanda Jordan, on behalf of the defendants' appellants, the TWRA, Bobby Wilson, Ed Carter, and Kevin Huffman. I would like to reserve 2 minutes for rebuttal.
All right.
This case challenges the constitutionality of Tennessee Code annotated section 70-1-305, which gives TWRA and its officers the authority to go upon any property and outside of buildings, posted or otherwise, while enforcing all laws related to wildlife. The plaintiffs filed suit seeking declaratory and injunctive relief that TWRA's entry statute is unconstitutional both facially and as applied because it violates their rights under Article 1, Section 7 of the Tennessee Constitution to be free from unreasonable searches and seizures. It's the state's position that the circuit court's order finding the entry statute facially unconstitutional should be reversed because there is no justiciable controversy to maintain an action for declaratory relief, and the statute is not unconstitutional. First, with regards to the finding of a justiciable controversy, defendants contend that there is no live case or controversy here to give rise to a declaratory judgment action.
General, so is the argument you're advancing one of mootness in this case? And I mean, justiciability is an umbrella, right? So is mootness the particular doctrine that we're operating under here in considering whether this case is justiciable or not?
Mootness and possibly ripeness, Your Honor, since there were past entries on the property, but at the time that the lawsuit was filed, there was no entry in over a year and a half.
The state has not, the state maintains that the action being engaged in here is constitutional, constitutionally permissible. If the state is maintaining that position, then how, under the Norma Faye Piles case, can this action be regarded as moot? If the state's saying, look, we did it, we think it's constitutional, we do it again, how can this action be one that's viewed as moot?
I'm not familiar with that case right off the hand, Your Honor, but here it's speculative whether or not TWRA is going to enter any of the plaintiff's properties. They could also decide to stop using their properties for hunting and fishing activities, which would then eliminate TWRA's need to enter the property to check for compliance with wildlife laws.
All right. Insofar as you're pushing on the ripeness side, so in ripeness case born and mootness did it die, on the ripeness side of the analysis here, hasn't the fact that TWRA has already entered the property rendered this a case that we can't say it's not ripe, it hasn't been born? I mean, it seems to have been born by the fact TWRA entered the property in the first place.
I think you still have to look at when that last entry was and to whether or not how speculative it is of any other future entries to establish a live case or controversy here, Your Honor.
Are the cameras still there on the property, counsel?
No, and that was one of the undisputed facts in the trial court level, that there have been no cameras placed on the property since 2017. And in fact, it's undisputed that the cameras that were there were owned by the United States Fish and Wildlife Services.
But placed by Tennessee, not by federal officials, is that right?
Placed by TWRA officers while assisting the United States Fish and Wildlife and under their federal delegation pursuant to a memorandum of understanding between the TWRA and the United States Fish and Wildlife.
Okay.
Is TWRA required to engage in that action as a matter of federal law? I mean, does federal law mandate that they engage in this action, or is this a voluntary action undertaken by TWRA?
In terms of them assisting with federal investigations. There are some wildlife violations that are both federal and state. So any violations under the Migratory Bird Treaty Act invoke both federal and state jurisdiction. So TWRA might first learn of it and then pass it on to the feds to see if they are willing to open an investigation. And then from that point, TWRA is there as assistance if the feds need it.
With regard to the substantive question, the Article 1, Section 7 question in this case, possession seems like the key textual word that we're wrestling with here under Article 1, Section 7. Why isn't an individual going on a walk in the woods, camping, hunting, why isn't that a possessive use of rural property? Isn't that an appropriate use of rural property to go for a hike in the woods, to go hunting, to go camping on it? Isn't that something that makes it a possessive use rather than wild wastelands?
I think the line of cases that were cited in the briefs really show that the courts look to the specific area where the entry or the contraband is found to make that determination. And it really depends how close in proximity you are with regards to the occupation or any kind of residence on that property to decide. So kind of an analogy is you have 100 acres of property and maybe you're only really actively using 50 of those acres and the other 50 is wild or wastelands. So the fact that you use that 50, does it bring the whole 100-acre parcel into a possession under Article 1, Section 7? I think that's what the line of cases shows, that you really have to look at the specific area.
Does the record provide a clear delineation showing that the entries were only in areas where the homeowners or property owners were not going hiking, weren't hunting, weren't going camping? And does the record establish one way or another whether the particular areas of entry were those where those activities were not occurring, or whether they were areas where those activities were occurring?
I think the record shows that the areas where TWRA was and where they entered are areas open where hunting is taking place, which is why TWRA was entering the property to begin with. And
if hunting is occurring in that place, why isn't that an appropriate possession use of rural property? And if it seems like that's something a lot of folks would do with rural property in the state of Tennessee, is go hunting on that property. Why isn't that something that makes it a possession rather than wild wasteland? I mean, the person's putting it to use, right?
I think the cases say that it's a use within the daily use of the premises. Like if you were farming and the operations are near your daily farming or your crops is how it's been interpreted. I don't think the act of farming alone, misspoke there, of hunting alone is enough to bring it within a possession. And that also turns to the reasonableness argument as well. So I can just fast forward to the constitutional issues here. That really, at the end of the day, the issue is whether or not these entries are reasonable under the particular circumstances in this case. And that reasonableness determination is done by evaluating the degree to which it intrudes on an individual's privacy with the degree to which is needed for the promotion of a legitimate public interest. Here, it's the state's position that any entry by TWRA is reasonable and done in furtherance of the agency's duty to conserve and protect the wildlife of the state so that Tennesseans can continue to engage in hunting and fishing activities. The state is the sole title holder of wildlife within the state, and as such, the Tennessee Constitution in Section 11, or Article 11, Section 13, gives the General Assembly the authority to enact laws for the promotion and preservation of game and fish within the state. And it's also that same provision that gives citizens within the state the right to hunt and fish subject to reasonable regulation.
John, would you agree that if police officers entered onto property that was used for farming purposes, let's say it's used for farming purposes daily, are farmers out there constantly making use of this property, that in that scenario, if we had the property being utilized in this way, that police could not enter the property to conduct a criminal investigation if they thought without a warrant that they would, or unless some other exception to the search warrant requirement was applicable. So they want to investigate a crime against persons or property. They couldn't enter under those circumstances. It wouldn't be a reasonable entry then, would it?
I agree that while normal law enforcement officers might not be able to enter under those circumstances, it's the particular purpose and function of the TWRA which makes such warrantless entry reasonable, because you're balancing the property owner's right to privacy of that property with the state's interest of furthering the goal of protecting the wildlife within the state.
General, if police can't enter, though, to investigate a crime against persons, let's say, why can the TWRA enter to investigate with regard to adverse actions being taken as to animals? Why is that more reasonable for TWRA to enter under those circumstances than it would be for law enforcement to enter if they think a crime is being perpetrated against a person?
Because it's a different interest. You have to look at the state's interest in furthering its duty of protecting and preserving the wildlife within the state that is transitory in nature. So if people are allowed to hunt on private property, then TWRA, in furtherance of that goal, needs to be able to enter private property to check for these licensing compliances and to make sure that they are complying with all of the wildlife regulations, so that certain species, if they are on a threatened or endangered list, are not being killed, that hunters aren't shooting over the bag limits, to make sure that everyone that wants to partake in these hunting and fishing activities has a fair opportunity to do so. So it's the state's separate interest here that's different from regular law enforcement officers that make these entries reasonable under these circumstances.
Doesn't the state have an even stronger interest in protecting persons than wildlife? So if you can't enter to investigate a crime being committed against a person, law enforcement can't. And let's say that's the primary duty of the state, to protect the people of the state. Why is the interest greater to enter to protect wildlife? I'm still struggling to see why that makes this reasonable. Why is this entry reasonable when it wouldn't be for law enforcement to investigate a crime against a person?
They just have a separate statutory duty for that.
Let me ask you, you cite Article 11, but there are limitations on the rights granted under Article 11, and I think they have to give way to the rights indicated under Article 1, don't you think? Where you
Yes.
can't, go right ahead.
No, that's why has to be some kind of balance. It's TWRA has a right to protect and preserve the state's wildlife. Citizens have a right to hunt and fish in the state subject to reasonable regulation. While that can't trump their privacy rights, there still has to be a balance of that. And it's the state's position that this entry statute balances those rights, because TWRA is only coming on the property if they believe that hunting is taking place or has taken place in the past. The statute limits their authority to only for the enforcement of these wildlife laws. And there's another part of the code that prohibits them from searching inside of buildings, businesses, or the inside of an automobile without a warrant.
Why is it unreasonable from what you've just said, that they wouldn't go on the property essentially unless there was probable cause to believe that there was hunting going on? Why is it unreasonable to require them to get a warrant to go onto the property?
Because there are some circumstances when you're checking for licensing compliance that you might hear someone hunting on the property, but you're not necessarily going to know the identity of that hunter, so you're not going to have the information that you need to get the warrant, or if you do, by the time you go and get the warrant and come back, that hunter is gone. And my time is up, Your Honor. Do you have any other
All
questions?
right, now you have your rebuttal time.
Yes.
Thank you.
Good afternoon, Your Honors. My name is Josh Wyndham, and I represent the plaintiffs' appellees, Terry Rainwaters and Hunter Hollingsworth. In this case, and excuse my voice, I've been getting over an illness, and so I'm just recovering my voice for you all today. For almost 100 years, the Tennessee Supreme Court has held that Section 7 forbids warrantless searches of land that is used or marked as private. That's a low bar. The entry statute turns that 100-year line of protection on its head. It allows TWRA officers to enter and roam around private land, fishing for evidence of crime. It doesn't require consent. It doesn't require warrants. It doesn't require probable cause, to your point, Judge Golden, and that's at volume 4, page 509 of the appellate record. It's a blank check for officers to invade private land whenever and however they please. The trial court correctly held that the statute violates Section 7, and this court should affirm. I want to start with the merits, and then I'll circle back to some of the justiciability points that Ms. Jordan has raised. So on the merits, the warrantless entry statute violates Section 7 in two basic ways. It authorizes unreasonable searches of possessions, and it functions just like the sort of general warrant that Tennessee's framers prohibited in 1796. On the unreasonable search question, warrantless searches are presumptively unreasonable. That is the balance that the framers struck in 1796. Generally speaking, officers have to get a warrant unless the state meets its burden of invoking and proving an exception to the warrant requirement. We heard a little bit earlier from Ms. Jordan about the need to balance and the government's need to enter these properties to enforce the law. That is always true when the government is enforcing laws, including criminal laws on private land, as Judge Usman pointed out. The state's position in this case seems to be something like people have less protection under Section 7 when they're exercising their constitutionally protected right to hunt than they do if they're bootlegging, as was the case in Welch, or if they're manufacturing drugs on their land, as was the case in Lakin. That can't be the rule that prevails in Tennessee.
Counsel, I have a question about the facial versus as-applied aspect of this. You seem to be using Patel as a limiting of the traditional notion of facial as all applications have to be rendered unconstitutional. It's only where it's needed, essentially. If it's wild wasteland, you seem to suggest in your argument that, well, you don't really need it because there's no constitutional protection as to wild wasteland, so the statute doesn't make any difference. But don't you need the statute here if you're TWRA? Isn't an entry, even onto wild wasteland property in Tennessee that's owned by somebody, isn't it a trespass under Tennessee law?
No. So first of all, they have authority under a different statutory provision in the Wildlife Code to enforce wildlife laws and to conduct inspections, generally speaking. So they actually don't need this statute to go onto wastelands. And the statute I'm referring to is 70-6-101. So they have separate authority statutorily to do this. What they need this statute to do, and where the statute is doing work, and that's the language from the Patel case, is to enter land that is constitutionally protected. And that's the fundamental problem with this statute. Any situation you can imagine where a property owner would have constitutional protection in their land, where they have done what the Welch case says to do, which is either make efforts to exclude intruders, put it to appropriate use, like hunting. Judge Usman, you raised that point earlier. Farm it, cultivate the land, fence the land, anything you might choose to do to get protection under Welch and its progeny. The statute says they can go on because the plain text of the statute says posted or otherwise. It's not the case, by the way, that just because somebody is engaged in hunting, as Ms. Jordan said earlier, that's what triggers these entries. No, it's undisputed that officers go onto private land when they think people are hunting, yes, when they think people have hunting licenses, as Terry and Hunter do, when they think people have ever hunted on their property, as will always be true for Terry and Hunter, even after if they choose to stop hunting tomorrow, it will always be true that they've hunted there in the past. And TWRA says that's all we need to go in. It's even undisputed that they go across non-hunters' properties to get to a property they want to patrol. And so there's no land in the state that really escapes the reach of this statute. And the problem, and this is why it's facially unconstitutional, is that in every situation where it authorizes entries of property, it authorizes non-consensual warrantless entries. Again, we don't have an invoked exception to the warrant requirement. In fact, as we note on page 26 of our brief, Ms. Jordan affirmatively waived several exceptions to the warrant requirement in the trial court. She waived the implied consent argument, she waived the special needs argument, which falls under the administrative search exception. She waived the closely regulated industries exception. I don't know why she waived them, but she did. And so we're here today in court with Ms. Jordan not having raised any exceptions to the warrant requirement and making kind of generalized reasonableness arguments about it, when again, warrantless searches are presumptively unreasonable. And so that's why the statute is facially unconstitutional. It's also unconstitutional as applied to my client's particular properties. If the court turns to page 34 of our brief, we've put together a table that I'm sure you've seen that goes through all 8 of my client's properties, and it runs through the indicia of ownership on all of them. And it's sort of a dealer's choice. If the court wants fencing, look at Terry's Liberty Road farm. Look at Hunter's 19-acre residential wooded property that has a fence all the way around it. If the court wants posting, 5 of the properties are posted at the entrance with no trespassing signs. If the court wants active farming, cultivation, which is what Welch talked about, then most of these properties are actively farmed. Hunter's property is farmed. Terry is a commercial farmer, so almost all of his properties are farmed actively.
Opposing counsel draws a division, and you could have a 100-acre piece of property. 25 of those acres could be wild wasteland, 75 could be being put to use. Does the record clearly establish that the points of entry, where TWRA in this case was, were in spots that were being used, whether for hunting, fishing, or hunting, camping, walks, that those places were being utilized?
So the record establishes, and this starts at page 1,220 of the record. If the court goes through the next couple dozen of pages, you see this line of stipulations we've entered into. The record establishes that at the entrances to these properties, there are signs of ownership like gates and no trespassing signs. Throughout many of the properties, there's active farming. Of course, it's true that if you took a photo, as Defendant Huffman did, in the middle of a property, you might be able to take a photo of what looks like a forest or a field. But Defendant Huffman had to get to that location in order to take that photo. He didn't helicopter in or something like that. He wandered around the property and he took a photo of what looked like a field, of course, but he had to patrol through land that did have signs of ownership. And I would note, if the court looks at cases like Lakin or cases like Castile, what the court is doing in those cases is it's saying, let's look at the record evidence in this case, and is there a sign of ownership on this property? The court doesn't say there has to be a sign of ownership every 5 feet or every acre. What the court says is, are there indicia of ownership? And it's an objective test. So it doesn't depend on Defendant Huffman's subjective knowledge or anything like that. And if there is indicia of ownership, that is sufficient to make the property a possession under Welch. Again, it's a low bar. The only case that I've been able to find at all that holds that a piece of private land is not constitutionally protected is Dolman. And in the Dolman case, the Court of Criminal Appeals said that a heavily wooded property with 0 indications of private ownership was not a possession.
Counsel, with regard to the nominal damages in this case, why isn't this within the ambit of sovereign immunity? Why isn't this something that you can't recover nominal damages for, given the circumstances of this case?
We sued Defendant Carter in his individual capacity. That's right there in our amended complaint. We're seeking $1 from him individually. We don't seek a single dollar, cent, or any sort of property from the state or the state treasury. Colonial Pipeline tells us that sovereign immunity only applies when you're suing state officers in their official capacity, and so we followed that instruction and didn't sue officers in their official capacities, and when you're seeking money from the state. And we're not seeking money from the state.
Has the GTLA been raised in this case as an issue? Are there any particular statutory applications that have been raised or brought to the attention of the court?
No, it hasn't been raised. I just want to pivot with my remaining time to justiciability. Actually, before I do that, let me make one final point on the merits, if I could. On the merits, so Ms. Jordan made a point about daily use of the property. That's language from a case called Chico in the 1960s. The Chico case the officers had a warrant. And so any language about whether there was indicia, whether there was daily use or what the test was for possessions, that was all dicta. The officers in that case had a warrant. And so that's one reason why Chico can't control here. Another is that Chico is post-dated by several cases, including Lakin, Dunham, Harris, Castile, and Dolman, all of which don't cite that language about daily use from Chico, but instead cite this very flexible disjunctive test from the Welch case about the various ways in which you can use or mark your land as private. And so daily use is simply not a requirement. And even if it were, if Terry and Hunter tomorrow decided to go out to their properties and use it every single day, the statute would still allow them to go on. So it's hard to see how that can make a difference in this case.
Counsel, on the justiciability question, how would you distinguish this case from a case like Lyons, where you have the chokehold applied by police officers in Los Angeles, and the United States Supreme Court says this is not a justiciable case when the party comes and tries to litigate, saying, we don't know that this is going to be applied to you again? Why isn't this a Lyons case?
The Tennessee Supreme Court has only cited Lyons once in its history. That was Memphis versus Hargett in 2016, and the court cited Lyons to distinguish it as a case that didn't involve a statute that hung over the plaintiff's head. This case involves a statute that hangs over Terry and Hunter's head. It has authorized several warrantless searches of their properties in the past. The agency is here today defending its authority to go onto their properties without a warrant. It is clinging to the power that the trial court held is unconstitutional. And so we have no reason to think that they won't use this statute to enter my client's properties again. In fact, it's undisputed that they don't keep records of when they go onto people's properties. And so when we talk in the briefs about the entries we are aware of, those are just the entries we're aware of. It's not undisputed there have only been 20 entries. They wander around in secret on private land. They wear camouflage. They observe people from behind bushes while they're hunting. They don't keep records of their entries. We don't know how many times they've gone on these properties, and neither does the state. Now, I do know the Norma Faye Piles case. In fact, it was cited recently in Shaw versus Metro, this Tennessee Supreme Court case from last year. And what the court said in Shaw versus Metro, actually, is that the government's burden, and this is on the mootness question you raised, Judge Usman, the government's burden, if it wants to show the case is moot because it's not going to rely on a statute again, is to show that there's no reasonable way to think this could ever happen again. I don't see how they could possibly make that showing. They haven't even tried, first of all. And again, it's undisputed. The statute's still on the books. They still want to enforce it. I don't know what else to say. I mean, Terry and Hunter are afraid to go out on their property. They're afraid to, sorry to be crass, but to use the restroom out in the open on their properties. They're afraid to hunt because they might shoot somebody who's hiding in the bushes. They're afraid to invite guests over because they might be spied on. I mean, this is not how people should think about their private property in Tennessee. And that's why we have a 100-year line of cases treating private property, treating private land as sacred, and holding that if the government wants to get onto that property to enforce laws, and I agree, hunting laws are important, but if it wants to go on these properties, it has to follow a constitutional process. Article 11, Section 13, which is another provision Ms. Jordan raised, doesn't give the state carte blanche to ignore Section 7. In fact, the very last sentence in Article 11, Section 13 says that this provision should not be construed to abrogate property rights, private property rights. Well, Section 7 is a property right. It protects your right to be secure on your land. Your Honors, in closing, unless there are further questions, in closing, this statute authorizes warrantless searches of all constitutionally protected property in Tennessee, including my client's properties. It tells TWRA officers that they can invade private land at will. They can roam around fishing for evidence of crime, and that there's nothing landowners can do to stop it. The trial court correctly held that that's unconstitutional. That kind of power is not consistent with Article 1, Section 7. This court should affirm. Thank you very much.
Let me ask you about the damage award. Was that against the officer while acting in his capacity as a wildlife officer?
It was against Defendant Carter, who is the former executive director of the agency, who oversaw all of these activities at a kind of high level. So
in his official capacity?
No. We sued him in his individual capacity. So there's no money coming from the state.
But when he was acting in that regard, was he acting in that regard because of his position?
He was, but the reason we sued him individually is that Colonial Pipeline tells us that when government officials, whether the head of an agency or a field officer like Defendant Hoofman, when they're enforcing an unconstitutional statute, that's not an action of the state. And so it's true, he held the position of executive director, but under Colonial Pipeline, he wasn't acting as an officer of the state, and that's why we sued him individually. We were just following that court's instructions. Thank you very much.
Thank you. Ms. Jordan?
Yes, Your Honors. I'd like to follow up on the nominal damages issue. The plaintiffs contend that Colonial Pipeline supports their case while they're entitled to nominal damages against Defendant Carter, but Colonial Pipeline actually does not help their case. Colonial Pipeline expressly held that a court may issue declaratory and injunctive relief against state officials in their individual capacity so long as the court's judgment is tailored to prevent the implementation of unconstitutional legislation and does not reach the state, its treasury, funds, or properties. Also, in the opinion in Colonial Pipeline, they say that in allowing exceptions for declaratory judgment suits against state officials in their individual capacity, that their reasoning parallels with that of the U.S. Supreme Court in Ex parte Young. So really implicit in that discussion is that when the court in Colonial Pipeline said you can sue these state officials in their individual capacity, it really meant in their as individuals in their official capacity, because the opinion goes on to clarify that the exception for declaratory judgment suits seeking to prevent the enforcement of an unconstitutional statute would not allow for money damages to be awarded against state officers because such suit would reach the treasury, the state, and its funds or property.
General, I have a quick trespass question for you on the facial versus as applied challenge. Do you agree with opposing counsel that there are other statutory provisions that would already allow TWRA to go onto, let's say, clearly wild wasteland property that would render that not a trespass? Or is this statute critical for rendering that action not a trespass by a TWRA agent?
This statute is needed so that that action is not a trespass.
Okay.
I believe the other statute that the plaintiffs were referencing is the statute that says that individuals who are partaking in hunting and fishing activities have to submit to inspection. That statute alone does not give TWRA the authority to enter private property. And I see my time is up, so to conclude, I would respectfully request that the court reverse the judgment of the trial court and remand this case with instructions to enter summary judgment to the defendants. Thank you, Your Honors.
Thank you, counsel. Very interesting argument. We'll take it under advisement and get you an opinion as soon as possible. Thank you.